I'm Andrew Rowe of the Law Office of Andrew Rowe, and in this video I wanted to talk about your estate planning options if you're in a situation where if you have one adult child who you wish to receive the property. There's a few options available to you, but wanted to help you unpack and understand some of the basic level options are available to you. When you have a single child who's an adult, it does clear up a lot of the issues, and it can be a little bit easier to account for, so it's then unpacking just what's important to you and how much coverage you want to have. What estate planning is hoping to accomplish is a few things, not just designating who gets your property, but it also ensures who the responsible parties are to administer your estate and making sure that your funds can be used to cover costs and expenses as they arise. Some of those steps are kind of solved when you only have a single child or a single beneficiary. By passing the property to them, if you have taxes to pay, they can pay it. Usually the issues arise when you have multiple beneficiaries, because if you give the property 50-50 to these people, who's going to pay the bills? Someone has to step up and the other has to reimburse. Then it becomes an issue. That's not really too much of a problem when you have a single beneficiary. And so because of that, that allows for really three categories of options that are available, but two of those options are a little bit more popular, and you'll kind of see why. So the first option is we can write a will. A will says, upon my death, give the property to this single beneficiary. That works, but a will has to go through probate. Probate is this process that the state has created about how to pass property from you to your beneficiaries, but it creates this whole long procedure along with it. The point of probate is it assumes that no one in the process is going to be trustworthy, and so it's subject to court supervision every step of the way. That's not really needed. Your single beneficiary can't steal money from themselves, and so there's not really much need for an oversight. We don't need to double check that the house is being sold for fair market value or not to a buddy. We don't need to double check that the administrator isn't stealing funds. So all of that procedure involved under a will is a little bit unnecessary. So the next option then is you can avoid probate. Instead of writing a will, is listing your child or single beneficiary as the beneficiary on every account. And that is a great option, but there are risks associated with it, and that's something I want you to be thinking about in deciding what's important to you. If you list that beneficiary as the beneficiary on every account, retirement, you can do this on real estate by drafting a transfer on death deed in Kansas, and then like life insurance beneficiaries, TODs, PODs, that then is giving instructions directly to the financial institution to transfer those funds or write a check to that beneficiary. That's great. That gets the property to them without the need for probate. The drawback that I've run into is just the backup plan is, what if that person, when they receive it, is on Medicaid or disabled at the time, or if they've predeceased you? In those situations, your plan doesn't account for those, and it kind of falls apart. So if that beneficiary is a Medicaid recipient or they're receiving government assistance, by getting money, they're kicked off of their benefits. The government would just say, oh great, we see that you've got some money. We no longer have to provide for your care, your whatever assistance they're receiving. They become ineligible. And since you don't have documents in place that account for that, that's just how it's going to be. So let's say I'll use a situation that we're paying the money to your only child and they themselves have their own children, so you have some grandchildren. If your one child dies, each institution then is going to have a different policy about how they're going to handle the fact that we have a beneficiary listed on an account who's deceased. Some banks are going to look at that and say, well, we'll write a check back to your estate, which requires probate. Some banks are going to look at it and say, well, we're going to write a check to this deceased beneficiary's estate. Some are going to look at it and say, well, since this person has children, we're going to pay it directly to those children. Each of those is a problem, because if they write a check to your estate, it needs probate. If they write a check to your child's estate, they need probate. If we write a check directly to minor children aren't legally allowed to have funds without setting up a conservatorship, which is kind of like probate. It's a court process to have someone appointed who's in charge of those funds until the minor children are old enough. Each of those creates an issue where it's going to require court intervention to solve, costing thousands of dollars, taking months of time, maybe involving one or multiple attorneys to get the problem solved. So this case might be unlikely. It still is something that if it's important to you to cover what happens next, if that one beneficiary predeceases you. If you want to come up with your backup plan and you want to avoid probate, then you'd want to look to setting up a trust. Now, in these situations, if that one beneficiary is alive, the trust probably would be overkill, because the whole point is if you want them to have the money, they would get it in the situation of beneficiary designations, for sure. And then that's just pretty easy. They can use the funds to cover your taxes and expenses, whatever comes up. But if it really is important to you to say, well, what if that beneficiary is deceased or disabled or on Medicaid, or if they're not good with funds? All those situations, if it's that important to you, you do want to set up a trust, because a trust will keep it out of probate court, still give the property to that intended beneficiary, but then you can come up with all these backup plans. If that person is deceased, here's who's next in line for paying the bills. Here's who will take care of the funds if there's minor children involved. Here's how long we will hold the funds until a person is mature enough to get the money. We don't want to just hand a bunch of money to an 18-year-old and say good luck. You can design around that if you have it in writing and put it together through a trust. So those are typically the two options. And I'd say that all things being equal, there's many, many more factors that go into this. So this isn't really the final answer, and don't take this as legal advice. This needs unpacking with myself or with an estate planning attorney. But all things being equal, if you're okay with the risk and you don't want to have it covered, just listing that single beneficiary on the accounts, that's a good option. But you don't want to assume the risks of what if this intended beneficiary is deceased, disabled, incapacitated, whatever the case may be. Then you're going to look to putting something more robust in place. So those generally tend to be the options available. This is so that you can start thinking it over, mulling over what your options are, but we look forward to hearing from you to help put together a plan.